Good afternoon, everyone. I'm Larry Verbit, Chair of the Entertainment Law Section. We want to welcome you for joining us this afternoon. Before we begin, I'd like to advise you of 3 events we are going to have next month in January. We generally sponsor a dinner with a 3-hour CLE as our Entertainment Law Section review of major issues impacting transaction, litigation, and ethical matters during the prior year. In lieu of the annual dinner and 3-hour program, this event will be presented on Zoom over 3 consecutive weeks during lunchtime. The transactional panel will present on Wednesday, January 13th, the ethics panel on Wednesday, January 20th, and the litigation panel will present on January 27th. You will, of course, be receiving more on these programs in the coming weeks. For those of you who are not members, we invite you to join the BHBA and our section to participate free in our seminars. And all are welcome to join the Entertainment Law Section meetings at 8:30 on the first Wednesday morning of each month. Until further notice, we are meeting by Zoom, so you can join us from the comfort of your own home. At this time, I'd like to thank our Section Secretary, John Baldivia, a partner at the Pierce Law Group, and Executive Committee member Michael Peters, who practices at Rama Law, for putting this program together rather quickly. John will be moderating the panel, and now I'll turn it over to him.
Thank you, Larry. As Larry said, I'm a partner at Pierce Law Group, and I'd help co-chair this program with Michael Peters. We think we have a great program for you guys today, talking about specifically the MLC. We have 2 great panels joining us today as well. The goal with today's panel is to provide you with as much factual information about the MLC and how it will be operating over the next year. I know many of us, including myself, have many questions about what the MLC is going to do, and today we have Kris Ahrend and Kay Hanley to answer some questions for us. If you haven't received it via email, the materials are available in the chat box. But you should have received an email for it before today's panel. So be sure to check there for the written materials. And I'm going to introduce the panelists now. So we have Kris Ahrend today, who is the Chief Executive Officer of the MLC, where he leads the organization's mission to ensure songwriters, composers, lyricists, and music publishers receive their mechanical royalties from streaming and download services in the US accurately and on time. Kris began his career in the music industry working in the law department at Sony Music, where he provided legal services to all of Sony's US divisions. He subsequently worked in the business and legal affairs department at Sony BMG Music Entertainment before accepting a senior executive role at Rhino Entertainment. And most recently, Kris served as a senior executive for Warner Music and led the development and launch of Warner Music Group's Center of Excellence for Shared Services in Nashville. We also have Kay Hanley joining us today, who serves as the vice chair of the Unclaimed Royalties Oversight Committee for the MLC, also known as UROC. Her and her songwriting partner, Michelle Lewis, are co-executive directors of Songwriters of North America, which is a nonprofit advocacy organization that fights for the protection and value of songs and songwriters in the digital music marketplace. Kay is a Peabody Award-winning music composer for animated television, penning original songs for shows like Disney Junior's hit series Vampirina and Doc McStuffins, DreamWorks' Harvey Street Kids, WB Cartoon Network's DC Superhero Girls, and upcoming Netflix series Ada Twist Scientist. So thank you both for joining us today. Kris, we're going to start with you. I know that you have a very informative presentation document that'll give us a good outline of what the MLC is going to be doing starting in January of 2021. So let me turn it over to you so that you can explain to us what's going to be, what we can look forward to.
Great. John, thanks so much. Really a pleasure to be here. I know I've joked, maybe no one else finds it funny, but I've joked that I wish we were Larry's. Every time I think of the Beverly Hills Bar Association, my mouth waters and I think of prime rib. So I look forward to seeing you all in person someday when we can get back to Larry's and enjoy our company. But the plan for today, as you said, I've got a short deck that I thought I could run through. Hopefully it takes about 15 minutes. That'll leave plenty of time for discussion and then questions. And on the questions, I think we talked about encouraging people to use the Q&A bar below as opposed to the chat. This makes it easier for us to track the questions as we answer them. But there'll be plenty of time for questions, so folks can feel free to pop them into the Q&A and we'll try to get to them. I'll also just say at the outset, I'm so excited to be here with Kay. Kay is both an extraordinarily talented songwriter and artist, one who I was a fan of before I realized who she was, because my kids were big fans of Doc McStuffins and some of the other shows for music. But she's been a really active and involved member of one of our advisory committees. We talk through the advisory committees once a month, and then we separately meet with her and some of her colleagues at SONA, which is a great songwriter advocacy organization. And she's a great example of how there really is an extraordinarily large team of people behind the scenes working together to make the MLC come into being. And I'm just really grateful for her partnership and her contributions. Songwriters should certainly know that they are well represented by Kay. So Kay, thanks for being here.
Thanks, Kris.
And let's take a quick look at a deck. Kay or John, do you see my screen?
Yes, we do.
Okay, so let's make this a little bit larger. And should also say hello to all the folks out there. I imagine there are a lot of LA-based lawyers, and I lived in LA for more than a decade, and certainly I'm excited to see some familiar names as we get into the program. So the MLC won't spend a lot of time on this. It was created pursuant to the Music Modernization Act of 2018. Suffice to say, those of us who've been in the industry for a while know that changes to the Copyright Act do not come along very often. The last set of major changes to be enacted were in the mid to late 90s, the Digital Millennium Copyright Act. Before that, you had to go back to the 70s, and then before that, it was 1909. So to say that this was a once in a generation event is certainly accurate, and for some, it was once in a lifetime. The act was far reaching and addressed a number of issues in the music industry, but the one of the three main titles really sought to address the failure of digital audio services to effectively license works and then pay mechanical royalties to publishers and songwriters. This was not a secret, and it was certainly not because the services didn't want to do it. As many of you know, the advent of digital formats really led to the explosion in the number of recordings and works that could be made available to consumers. And that explosion really grew with the shift to streaming, a consumption-based model where folks can now subscribe to a service or access a premium service and essentially listen to any sound recording that is available on the service, and as many of them as they want. In the case of subscription service, they pay that monthly fee. So unlike the days of vinyl or cassette or CD, even 8-track that some of us remember, when the number of records that could be out at any given moment was limited by and large by the shelf space in the store and the supply chain. In the digital world, everything is available all the time. And that meant that the existing system for clearing mechanicals, which since 1909 was done on a work-by-work basis, became really difficult, if not impractical, when you're talking about tens of millions of works. So Congress addressed this largely because there was such a broad consensus among all the different stakeholders, both on the content and creator side, and then also on the service side, that we needed a better way for this to work. And that's what led to passage of the law, and then under the law, the creation of the Mechanical Licensing Collective. Essentially, the MLC acts as a clearinghouse. It will receive data and money from the digital services that are operating under that blanket license. It will match usage data from those services with the musical works data that the MLC maintains. And then it will use those matches of data to distribute the royalties it receives to folks entitled to be paid. We'll talk about that a little bit more on the next slide. So this is a slide that I'll spend a minute on, and for all of you that have clients that will be impacted by what the MLC is doing, it's a great slide to spend a minute on and to use as a reference in a phone call you might make to a client, because there is a lot of confusion about what the MLC will do and what it will not do. And while some of you may look at the list on the right and think, well, this is obvious, what I can tell you is in every webinar we've done, and we've done, I think now 80 since May, we get versions of questions that are really reflecting a level of confusion about what we will not do. So I'll get to that in a moment, but what we will do at a high level, starting with outreach and education, which is not listed, but is evidenced by the fact that Kay and I are here. We have established and will maintain a public database of musical works ownership information. The public part of that will be launched in the next several weeks, right around the time we pass January 1st. We will administer a new blanket license that the law created. It's available to eligible digital audio services in the United States. So if a service is operating outside the United States, the blanket is not available for those ex-US operations. It's only available for the US operations. We will receive and match that sound recording usage data from the services with the musical works ownership data that we are maintaining in that database. And then we will collect and distribute the digital audio mechanicals that the service will to us. And this is the key, to publishers, administrators, foreign CMOs, those collective management organizations or societies around the world that have the right to collect mechanicals on behalf of their members, and also to self-administered songwriters. And we'll touch on that a little bit later, and Kay will certainly speak to that, because it is not all songwriters, it's just self-administered songwriters. So again, what we will not do, first one, we get this every time, we will not administer performance royalties. We are not by law allowed to do that. So the question we often get is, will the MLC replace my PRO? And for you, when advising your clients, the simple answer is no. The MLC will not and cannot replace your PRO. By PRO, we mean ASCAP, BMI, CSAC, GMR. We cannot replace those organizations or their functions. And similarly, they cannot administer the blanket license either. The MLC is the exclusive administrator of that blanket license. Second one, this reflects a second level of potential confusion, and that's because when people ask, will we replace Sound Exchange, it often suggests that they do not realize that Sound Exchange, although similar in that it administers a set of rights for the entire industry, it administers a set of rights that relate to sound recordings, not to musical works. The MLC administers mechanical rights which relate to musical works. So the simple answer is the MLC will not replace Sound Exchange either. And similarly, Sound Exchange is not able to do the work that we do to manage or administer that blanket license. Third bullet, we cannot by law administer audiovisual uses. This gets increasingly important as audiovisual services grow. So when folks say, what about TikTok? The answer is that's an audiovisual service. So we will not be administering rights or royalties related to uses of works on services like TikTok. We cannot administer mechanical licenses for any of those physical products that I mentioned earlier. So for CDs and vinyl in particular, which is a growing physical format, and then to the extent there are any 8-tracks or cassettes left out there, we are not by law allowed to administer mechanicals for those products. And as I said earlier, we are only administering the blanket, which is available to US operations. So even for a global service like a Spotify or an Apple Music, we can only administer the blanket license for the US service that those companies operate. And for the rest of the world, they have to secure their licenses and handle their mechanicals in other ways. One other one that's come up recently, lyric rights. We also cannot administer lyric rights. There's no confusion on our part about that. And I think our digital partners are also clear on that too. So no lyric rights. And all of this is to say, as you can imagine, when the MMA was being negotiated, there were lots of folks who said, well, maybe we should create, one organization that covers everything. But there were a lot of other folks who said, no, we should stick to the problem that I articulated before, and we don't need to solve things that are working well or reasonably well. So in that respect, each of these represents areas that ultimately Congress determined did not need to be addressed by a new or a different organization or a new or different solution. Kay, maybe I'll just I'll bring you in for a moment to touch on a minute how, for many of us in the industry, and certainly for creators, distinctions like what my PRO does or what Sound Machine does, those are often confusing, in part because our creator partners, they don't wake up in the morning and sort of segregate their creative selves and say, today I'm only going to do this particular, I'm only going to work on creating something that implicates this set of rights.
Right.
The creator, it's all the creation process, and it's only when it gets handed over to business and legal people that we start to slice it in these ways.
Right. So are we talking about the difference between the artist and the writer, and how usually one person contains both?
That's a great first example, right? A lot of people are both writers and performers like you. So
Yeah.
the reason they might not immediately understand the distinction between Sound Machine and the MLC is because day to day, they're not thinking about those two sets of rights as they go about doing what they do.
Right. And I mean, a lot of the confusion still around what are the rights of the sound recording and what are the rights of the copyright. And people still don't understand that a song is actually two pies. And the MLC is dealing with the writer side only and the publisher's share.
And similarly, on the PRO side, I think most writers have had a relationship with a PRO, certainly writers at a professional level, but there hasn't been another new organization to come on the scene for quite some time. So when they learn about us, that immediately raises the question, does this change what I'm doing with ASCAP or BMI, which again is probably how they think of it. They don't think of it as a PRO, they think about it as the organization with which they have a relationship.
Right. It's all very confusing, as we know. The learning curve is steep on this stuff.
So again, for those of you that represent creators, this does offer a great opportunity to pick up the phone and just to go over some of these basics to make sure that your clients are clear on those distinctions. It's always good to touch base with a business manager if there is one, or an accountant, because again, they will certainly appreciate the importance of each and every revenue stream, and they are not going to be happy if one disappears. So making sure that you're on the same page with them or they're on the same page with you, so that your clients are still receiving all those existing revenue streams, and then potentially the additional revenue that the MLC will be processing is a great thing. And we'll get to it a bit, how they might get paid directly or indirectly. So a little bit about the MLC as an organization. That's another nuance to everything. But in addition to setting up the process for administering the blanket license, we've also had to build a company. I joined the MLC at the beginning of the year, I think it was January 13th, and I was essentially employee number one. And from that day, we had to figure out every aspect of the company's operations, starting with how do we pay the rest of the employees that we're gonna have to hire, and how do we offer benefits, and all of the very practical things that one needs to do to run a company. For many of you practicing in entertainment law, you may own your firm or be a partner of your firm. So I'm sure you are no doubt intimately familiar with all of the things that go on behind the scenes to maintain your business. And for the MLC, it's no different. So we've been doing all of that work behind the scenes in addition to building the forward-facing or member-facing functions that we will need to serve our members since January. Our headquarters will be in Nashville, and that's a picture of the building where we'll be located. For those of you who travel to Nashville from time to time, we're in the Gulch neighborhood, right around the corner from the Thompson Hotel. That, of course, is right down the street from Music Row. So we're in the center of the city, very conveniently located, easy to get to, and hopefully within walking distance for many folks in the industry who come into town and stay at the Thompson or now the new W Hotel behind us. And we picked that location for that reason. We knew that we would be serving folks both in LA and New York, as well as lots of places in between, and we wanted to be accessible to folks who were visiting Nashville. Of course, for people that are in town, and there are a lot of music publishers and songwriters here, it's also centrally located for them and convenient to get to. So in Nashville. That said, we have team members in several cities, or will have them in several cities in the US and UK. And those cities include Los Angeles, New York, Miami, and London. But right now, we've got team members in more than a dozen states, and that's because, like all of you, we are operating fully remotely due to the pandemic. And many of our younger employees, when the pandemic started, they went back to where they were from, maybe went back to their parents' house, and they're sheltering wherever they were from. So while we expect a number of them will move to Nashville right now, we've got folks in Colorado and Pennsylvania, Virginia, Illinois, Texas, all over. And the one good news for us, because we really only started to bring on employees in early March, took us a month or so to come up with the plan for who to hire first and to begin to find the right people. We have largely operated remotely from the outset. I think I've probably met about 10 of the 45 employees that we now have hired in person. So COVID did not impact us in that respect. And I can say more broadly, it really has not had a significant impact on our operations or any of the things that we're building. So thankfully, the technology and the fact that we started the company post-COVID, we didn't have to deal with the transitions issues that many of you have had to deal with and that are very challenging. Timeline. So we're just about in the middle of the timeline here, and this is very high level, but we began rolling out our user portal at the end of September. That's well underway now, and we've got invites out to more than 7,000 members. Several thousand members have completed the process. Many thousands more are still in that process or need to initiate the process now. The ball's in their court. So certainly one thing you can do is check with your clients, because if they are a publisher or a self-administered songwriter, there's a reasonable chance they have an invite sitting in their inbox that they have not yet acted on, and now would certainly be the time. But that portal rollout began in the fall. We have been helping members check their data now for a number of months, even going back to the portal. And I'll talk about that for a moment in a few slides. The blanket takes effect in January, so services can begin to operate under the blanket as of January 1, which means we will begin administering the blankets as of that date. And there's been a lot of work and effort, pardon me, I skipped ahead, behind the scenes to work with DSPs of all sizes to prepare them for what they will need to do come January. If all goes well, we expect we'll start receiving usage files in February or in March. There are two different tracks that DSPs can choose for delivery. Depending on which one they choose, it'll be February or March. You might also be aware that under the MMA, there is a separate provision that allows for digital services that have historical unmatched activity to deliver that to the MLC for processing. And if they do that and also provide the required usage data, then there is a limit on liability for those unpaid prior royalties that they can take advantage of under the law. The deadline for delivering that activity is also February 15th. So there are a lot of things that will be happening in the middle of February for us. But again, assuming we get some money and some data, as I expect we will, then that will set us up to begin sending royalties out in the middle of April. So that's high-level timeline. I mentioned the portal. The portal is the interface through which our members, and that's the term we're using to describe the people whom we will pay. The portal is the way that members will interact with us and their data. Right now, the first version of the portal is available, and it allows for member user sign up, works registration, and works maintenance. So you can basically go in and see the works that are associated with a member profile if we've already created one, or you can begin the process of creating your member profile and then registering your works, and then make changes as you need to. We have already released 7 or 8 smaller releases after 1.0. So every week we're putting out new versions of the portal that have additional fixes and functionality enhancements. But it will be sometime next year in the spring before that first deadline or our first distribution that we release the second big version, which will then have the royalty statement module and also the ability to see unclaimed and unmatched activity that we will maintain. And then we have plans for future versions that address data analytics and management tools. But again, some of those things will arrive between the major versions. So the takeaway here is the portal is a piece of current technology, and it's a software platform like any other you might use. And so we are going to continue to evolve that platform over time indefinitely. It is not a static piece of software that will be unchanged. It's also new technology. That's one of the things that we have essentially built from scratch in the last 12 months. So unlike the black screen, green font interfaces that some of us are used to seeing in our industry, because a lot of the software we use is quite old, this is new technology. It works on laptops, phones, iPads, whatever your device, and it's meant to be clean, modern, and very user-friendly. The technology is certainly a key part of what we're doing, but in some respects, an even more important part is our support team. We have recognized from the outset that we are a service organization. That's one of our key guiding principles, service. And in furtherance of that, we launched a support team in October before we really had brought in a whole lot of folks into that portal process to be there to support all the members that we were going to bring in. And we took a pretty aggressive approach on hours of operation. So as you can see, we're available 12 hours a day, 8 to 8, Monday through Friday, and then another 9 hours on Saturday. That Saturday availability is pretty unusual in our industry, but we felt that it was important to be available on Saturday, particularly for smaller publishers and perhaps self-administered creators who may be doing other things during the week, but want to sit down on a Saturday and tackle some data issues, or again, get set up in the portal. So we are here. This is all active. You can reach us by phone or by email, and within the portal via a chat mechanism. And you don't have to be in the portal to call. So if any of you have questions and you want to reach out to the team, please feel free to do so. We've done a lot to try to train them to be prepared to answer the questions we think we'll get. But the more questions you ask, the more likely we are to stumble on a question we didn't think about. And that's not a bad thing, that's a great thing, because that allows us to then think through that question and come up with an answer that we have for the next time. So this is not about stump the support team, it's about asking your questions, and we'll do our best to answer them. And if we can't, we'll figure out the answer and then learn from that exchange. Data quality. As a lawyer myself, I can tell you I've taken quite a personal journey over my career. I started, like many of us, not believing I did math, which meant I never had to open Excel. And since I didn't open Excel, I didn't do data. Because data is one of those things that requires numbers and a platform like Excel to work with. So data was not always something that I knew, but it's really important to all of us now. And I think many of you realize that. I think it was 5 years ago now, I spoke at USC at their entertainment law conference, and I said to a group of lawyers, whether we like it or not, we all have to become data scientists now. It's just part of the world we live in. So the Data Quality Initiative is a really important and new tool that we created for members to compare and check their data. But the concept is really easy. It's basically a red line, to use legal terms, for data. So if a participant sends us a file of their data, their musical works data, and provided it has one or of two identifiers that we use to kind of connect it to the data on our end, and they deliver it in the format that we've set up, which is an Excel template, so it's not sophisticated, we then run that file against our database, and we generate a comparison file that only shows the discrepancies. It's like a red line that only shows the parts that were changed. And in that way, we take what often feels like a haystack and we only show you the needles. For people that manage data, this is a really helpful tool, because if you manage, say, 1 million works or even 100,000 works, you can't go through them one by one to check and see, is this right, is this right? But this allows you to hone in on only the discrepancies between the data that you've submitted to us and the data that we're maintaining. And then from there, the results are delivered in Excel, and there are a bunch of different discrepancy codes. So you can filter in and out to hone in on particular things. Like, for example, is there a disagreement between the names of the writers? Or is there a disagreement between the shares on your end and ours? And those things allow you to quickly then find the things that need to be fixed so that you can get your data in the best shape possible. So again, think about it from a legal perspective as it's a redlining tool for data. Interestingly, it didn't exist before in this kind of form, probably because most of the folks maintaining data before us and even others today, the data that they maintain, they view as a private asset, it's proprietary. But because our data will be a publicly available resource, we didn't feel there was any reason why we couldn't run this kind of comparison. We want people to understand what we have versus what they have so that they can help us correct issues that we have on our end, or see that maybe there's something in their end that they didn't realize was out of date that they could correct. And that way we're trying to align data sets between our members and our database, which of course is the database we use to distribute all of those royalties. So the numbers are certainly growing. We're actually now at about 350 participants, and we're about 14.5 million, approaching 15 million works compared. There are webinars on our website you can check out if you want to learn more about this. And as I said, this is largely an Excel-based process. So while it works for the largest publishers, and we have in fact compared files with millions of works, I also know that it works for the smallest self-administered songwriters or publishers who may only be comparing 100 works. It's equally effective, and it's available for any and all, and it can be run as many times as you want. It's meant to be an ongoing diagnostic tool. So as you speak with your clients about data, this is something you can recommend to them, and it's a great way for them to get their data in shape before that first distribution.
Kris, can I ask a question there?
Yes.
If a songwriter or if the client has a publisher, can they access DQI, or is it just the publisher that can see that?
A songwriter could also submit a file of works if they wanted, but if they are not administering the works because they've signed a publisher, then they would have to work with their publisher to submit changes. So in that sense, the two kind of steps that I described may be separate. But that's a great segue into the next slide, Kay. And I'm going to bring you in on this because while every music publisher will need to connect with the MLC, because we will be the only organization by law that processes those royalties paid under the blanket license. For songwriters, the question is a little more complex. Many songwriters today work with music publishers or administrators, and they're very happy with those partnerships or those relationships. And part of why they partner with those types of organizations is so that those organizations can handle administrative tasks like collecting royalties from an organization like the MLC. So if you are a songwriter, you represent a songwriter, you will inevitably be helping them to answer the question, are you a self-administered songwriter? And if so, for which works? So these are examples of the questions that you can ask. Are you signed to a music publishing deal? If the answer is yes, you're probably not a self-administered songwriter because, again, most music publishers take on this responsibility of collecting mechanicals and other revenue as a part of their responsibility under those deals, but you as their lawyer can certainly confirm that for them. What you can also confirm is the extent to which that deal covers some or all of the works written by that writer. And Kay, I'd love to pull you in to talk about that because that's something that I think sometimes those of us who are not writers may miss or not think about when we think about things like this.
Mm-hmm. So which part would you like me to tackle?
Talk about how, and you can use your own career as an example, how many very successful songwriters are not entirely self-administered or entirely administered by someone else. It can vary. It can be a mix of both.
Right. So yes, and I think that a lot of people are, especially songwriters my age, are in this position. I signed my first publishing deal with my my band, Letters to Cleo, in like 1990, I think. And so I didn't realize at the time that I was actually embarking on a career. So that all three albums and, you know, all the other stuff we wrote was part of this publishing deal with Famous Music. And then I did some solo stuff, which was also part of that deal. And then the term was up. So I became a self-administered songwriter, which meant I was now the publisher. I didn't really realize that. So I have another decade of stuff that I own the publishing to, and then I have all this other work for hire stuff. So my catalog is a mishmash of published works, and that I am co-publisher, stuff that I am 100% publisher, and stuff that is 100% published by, say, Disney. So it is quite a task trying to, you know, do a data cleanup on a catalog that looks like this. And I'm definitely not alone. So this is a big challenge for people.
And it's another example of where, you know, as lawyers, we can be very helpful to our creator clients, because we've been working with a writer like Kay since 1990. You're probably going to know that history as well as your client will, about the deals they did and the scope of what they cover. So you can help them ascertain which works are covered by those publishing deals, which works may, again, be works for hire that are essentially not relevant at all for these purposes, and then which works the songwriters retained. And again, another facet of the kind of move to digital is songwriters have the ability to put works up themselves in ways that they didn't 20 years ago, when they were dependent on a record to be released by a record company. And that can be true for lots of different types of writers. Go ahead, Kay.
I would say that the number one helpful thing or number one helpful way that an attorney can guide their client in this area is to create and maintain a database of works that contains the title of the song, the splits, the PRO, you know, just the basic data, and maintaining that over the years. Because most songwriters don't really think like, oh, I'm going to be doing this for 30. I certainly didn't, you know, I didn't think I'd end up with 1,000 titles. But had I may have been a little bit more vigilant.
And I think you are not alone in that, again, the digital marketplace suddenly brings all of that historical catalog into play. Mm-hmm. And at the outset of your career, it may just have felt like you go on to the next, you go on to the next, you go on to the next. So again, I think that's a place where lawyers can be very helpful in helping clients both understand the deals and then organize their data. But again, the questions: are you signed to a publishing deal? Are you working with a publishing rights administrator? There are a lot of administrators, in particular in Nashville, there are a lot of independent rights administrators, though there are also folks out in California, and I'm sure other places that do that. And essentially, they do the administrative part of what publishers do, not the creative parts of what publishers do. But for purposes of the MLC, the effect is the same, and that is they can manage that process. If your client is based outside the United States, they may be affiliated with a collective management organization, a society that represents their rights and collects mechanicals on their behalf in the United States. So that's another question to ask. And then if not, you know, have you retained those rights? And we think about it as the rights to register your own works and to collect those mechanicals. And of course, your client may be doing that with a business manager or an accountant, but if they're doing that through a service provider like that they've hired to do it, they are still the publisher, versus if they hire an administrator and essentially assign the rights to do that to that person. So that's another distinction that can be tricky, and you as lawyers can help them. So we spent a bit of time on this, but I think it's important, and in particular to note that it is not binary. It is unlikely that many songwriters would be all or nothing. It's more likely that they will be self-administered for some works and not for others. And our goal is to make sure that where they are self-administered, that they find a solution for connecting with us. Could be that they do another deal with a publisher or an administrator. It could be that they use their sound recording distribution company, their independent distribution company, to also collect mechanicals for them, as increasingly services like that are now offering publishing admin services. Or they could decide to do it themselves. But you can help them figure out the right strategy and ensure that one way or another they're getting all of the mechanicals due to them. I'll try to wrap this up now. I think this is the last slide, and we did get into some of the discussion, and then I see some questions, and we'll make sure we start looking at those. But the last slide, if any of you represent a digital service, and maybe I'll just be a little more specific, this would be digital audio services, download services, or interactive streaming services. It could also, in theory, cover ringtone services, the versions of mobile products that are sold, though those are also declining. But interactive streaming and downloads are the primary services that are covered by the blanket. If you represent a service that does one of those things in the United States, the law is going to impose some requirements on them that they need to know about, and those requirements kick in January. So please connect with us on their behalf or encourage them to do so. To date, we have had direct contact with more than 60 DSPs, and there are only 4 or 5 that we're aware of now that we are still trying to connect with, and I believe all of them are based overseas in Asia or Africa, and it's not clear to what degree, if any, they will even be eligible for the blanket. So I'm hopeful that we have caught and connected with all of them, but just to be safe, please check in with your digital service provider clients. As I said earlier, if you're a music publisher, an administrator, or a CMO, encourage your client to become a member. If they don't, then they will not be collecting their digital audio mechanicals in the United States. That is an important revenue stream. And as folks playing those roles, not only will they be leaving money on the table for themselves, but they'll also be leaving money on the table for their clients. And then if you represent a songwriter, again, work with them to determine to what degree they are self-administered, and then help them organize their data. Check data is sort of the catch for everybody. We want everyone to try to check their data. And again, the DPI can help. I'll just touch on one last thing at the top of the slide. Membership is free. I use the word member, and we chose that because it, again, reflects the notion that we are providing a service, but it's not membership like a black credit card or platinum credit card where only some people can get it. It's not a velvet rope thing. Membership is free. If you're entitled to collect mechanicals, you can become a member. And the way that the law was set up, the MLC's operating costs are covered fully by the digital services under a separate assessment. So they have to pay those operating costs and then pay 100% of the royalties. And we can't mix those two either. So 100% of what we collect in will ultimately go out, and then the operational costs get handled separately. That's quite a change, and that most collective management organizations today essentially cover their administrative costs or their operating costs by applying or deducting an administration fee from the royalties they collect. So they may collect $100 million and pay out $90 million, then they use $10 million to run their operation. All of our operations are funded by the digital services separately. So I think that is the end of the deck. And John, I'll pause for a minute and let you jump in if you want to pick up any particular threads as we check out the Q&A.
Yeah, certainly. Look, we've had a lot of great questions coming into the Q&A. I know one of the questions that was asked was whether or not these slides would be available, and they have just been made available on the link in the chat. So if you haven't seen that already, please do so. We are going to get to some Q&A at the end of this program, and I know we've got 15 minutes left, but we will go a little bit over just to try and get through as many questions as we can. I do want to turn the discussion briefly over to Kay to tell us, just give us an overview of what you see the Unclaimed Royalties Oversight Committee to be doing in the beginning, and what your goal is as part of the UROC committee.
Well, first of all, thank you to Beverly Hills Bar Association for holding this webinar. This is really important stuff, and thanks, Kris, for inviting me to be here today. So the Unclaimed Royalties Oversight Committee is, our goal is to create an environment to create an environment where the black box is zero, that every work will be matched. And of course, it's not it's not going to happen right away, but one of the ways that we get there is by having an educated songwriter community. And that's where, wearing my SONA hat, We have created a multimedia campaign called Sexy Metadata Action Group, SMAG, to help songwriters really embrace the idea that metadata is power. And if you understand that, like when you walk into, for songwriters, walking into a room and having the business conversation is historically really uncomfortable, and we're trying to change that. And when songwriters walk into a room and have the conversation about like, what are the splits? Who is your PRO? And creating and maintaining that database, as we were saying earlier, that is going to create clean data. Clean data is valuable data. Clean data also means that there is no black box at the end of the day. So that's what we're doing.
Okay. And speaking of the importance of metadata, I don't know what percentage of our community is independent songwriters. So maybe there are people on this program that haven't been doing this, or just haven't had the experience working with a digital distributor, so they're not used to the idea of sending and tracking metadata. Could you just briefly explain what that is and why it's important for our songwriters or our songwriter clients to keep track of metadata? Like, who are they providing this to? Is it to the service providers? Is it to their publishers? How are they doing it?
Well, metadata is really, I mean, surprisingly human. The numbers are, so there are 3 metadata points that SONA is most concerned with. That's the IPI, interested parties information. That is the number that you are assigned by your PRO. Your IPI is you. There is the ISWC, which is the work. And someone's having some glass party out there. And then there's the ISRC, which is the recording. So those are so that sounds very terrifying to most songwriters. Like, what is that? But really that is, your metadata is you, the title, your co-writer, and the work that you create in the studio. Those all transfer into numbers and codes, but really what you're providing is basically your name, the title of the song, your co-writer, the splits.
Okay. So for those songwriters who are of the position that basically say, I'm just a songwriter, I give my music to other artists, they deal with it, I let their labels handle it. How do they get that ISWC, ISRC information so that they can make sure that they're tracking their royalties properly?
Well, you can't just turn over nothing you can't just hand a song over to a label if you're an artist, or a publisher if you're a songwriter. I mean, there is certain information that you have to deliver. And if you don't have to worry as a songwriter about the ISRC and ISWC. I mean, you will with if you're self-published songwriter and you're registering your works with the MLC, you will have to have an ISWC. Is that right, Kris?
You don't need to have any of the unique identifiers, but it certainly helps.
Yeah.
The point that Kay made initially, the writer's name is data. The name of the song is data. The name of the sound recording is data. If you go to our website, www.themlc.com, one of the resources that we've got available, and it's been downloaded, I think it's about 1,000 times now, is a music data organization worksheet. It's simply a one sheet in Excel that you can print out that shows you the data points you would need to register a work. And most of it, as Kay said, is information that a writer will know because it's the name and the song. The 3 main identifiers that look more like what we think of as data are the IPI number, which can be assigned to a writer or a publisher. And that's usually issued today through a performing rights organization in the first instance. The ISWC, which is the unique identifier for the musical work, or the ISRC, which is the unique identifier for the sound recording. You can look up ISRCs on Sound Exchange's website. They are now the preferred and maybe exclusive administrator for the RIAA in the United States. The ISWC you can look up on CISAC.net or CISNet, I think is their service. CISAC is an international musical works organization, and they have a public database of ISWCs. The IPIs you can usually look up on the PRO websites. So those are places you could find those. But again, not every writer will have those, and some will not have any of them, because the MLC is not just about paying super successful professional songwriters like Kay. It's also potentially going to pay the buddies of mine in high school that are still playing in bands and release songs on Spotify that a couple hundred family and friends listen to. And maybe that amounts to $10 a year, but that's still $10 and they're entitled to it. So they don't need to have ISWCs and IPI numbers to get that money, but they need to sign up with us and submit some information. If we don't know who they are and what they've written at all, we have no information, there's nothing we can match.
Okay, great. I'm gonna get to the Q&A questions in a little bit, and I promise we're gonna go over 1 p.m. just to make sure that we get through as many of these questions as we can. But I do want to open up the discussion to both of you with a few softball questions, and some of it may have been touched upon in the presentation. If me as a songwriter, if I'm already registered with ASCAP, BMI, CSAC, or GMR, should I trust that the MLC will already have the proper information for my song credits?
No. No, for two reasons. One, because those organizations have not provided the MLC with data. And two, the performance data may be different. One of the questions that came up in the chat, I just saw it, I think it was from Jamie. Hi, Jamie. The MLC and mechanicals don't work the way that the rights do on the performance side, where the PROs automatically split revenue into writer share and publisher share. In the mechanical space, there's just a mechanical share, and that can all be paid to a publisher or can all be paid to a self-administered writer. So there is no division like that, and that's one of the reasons why this kind of shift of data can be tricky, because in part, like on the share side, is the PRO tracking the shares 100% for writer and 100% for publisher, such that the shares add up to 200, or are they kind of having them and saying 50% is writer, 50% is publisher, and that adds up to 100. So it gets a little confusing, but the answer is we did not get data from the PROs. So the fact that your client has data set up properly or not with ASCAP, BMI, CSAC, or GMR does not automatically mean that the MLC has that data, and that's why they should check it.
Okay. What do I do as a songwriter if I see something on the MLC's database that I'm not properly credited for?
If you're self-administered, you'll be able to go into the portal and update your data directly. If you are affiliated with a publisher or an administrator, then you should contact them, because they are presumably responsible for managing your work's data on your behalf, and let them know. And that is a really important point, one that comes up a lot. Our data will be available publicly for anybody to look at. So just because you're a successful, talented songwriter who has a publishing deal doesn't mean you can't check your data. And the data that we make available publicly will be the same musical works data that people see in the portal, and it'll be the same data we use to pay people. So in that respect, the musical works ownership data will be fully transparent, and writers will still be able to check it even if they're not managing the data through the portal as a member.
Okay, great. I'm gonna try and get through some of these questions now that have been brought up in the Q&A and in the chat. This one comes from Eric Greenspan. How can we check to see if our clients or / publishers are signed up with the MLC?
Great question. Hey, Eric, I hope you're well. Simple answer is you need to check with your clients. There's no public search right now of membership. Again, we're still very much in the process of getting people to complete the membership process. And there are a lot of invites out there right now via email. So the best advice I can give is it's a great excuse to check in with your clients and ask them the question. Have you gotten an email from the MLC? Have you thought about it? Are you connected? What I will tell you is, between our board and our advisory committee, we have a lot of publishers represented, and our publisher relations team has been contacting a number of publishers. So certainly the larger publishers, whether they be independent or the majors, I think there's a reasonably good chance that all of them are connected already because they've been a part of building the MLC since the beginning, since before I was there. But again, never hurts to ask, and that's what I would suggest.
Okay, I'm jumping around here, so if you guys see my my questions go out of order, that's going to explain why. This one comes from David Green. Given the mandatory nature, what will the MLC be doing to enforce compliance from intentionally or unintentionally non-conforming online content providers?
I can't tell you the 10 things we're going to do today because we're not yet there, but one of the MLC's responsibilities is to enforce the parameters of the blanket license to make sure that people that are operating under it are in fact complying with the regulations, and then also monitoring the market to see if there are services that are operating outside of it that are not doing something right. What we can't do is bring infringement claims. So if a service did not secure the blanket and they were at least purportedly operating under voluntary licenses, something that I hope will be relatively unlikely given the advantages, the extraordinary advantages of the blanket, then content owners will still have all the same rights and remedies to sue them. So we will monitor and enforce the regulations that relate to the blanket, and also the requirements that relate or apply to non-blanket licensees. There's a category under the law called significant non-blanket licensees. And those companies, even though they don't secure the blanket, they still have to provide certain reporting to us. They've got to contribute toward the assessment, and we'll be monitoring all of those things. If a service totally blew their obligations and was just not compliant, we can actually default them and terminate that blanket license. And that can have some serious consequences. So those are the kinds of things that we'll be doing. And great to hear you, David, too. Thanks for joining.
From a non-legal standpoint, we cannot possibly undervalue the power of social media to shame companies into doing the right thing. That's our plan.
It's a good
Yeah. Okay, this question comes from Adam Benjamin. Many independent songwriters work with companies like CD Baby, TuneCore, DistroKid, and the like to not only get their music on the streaming platforms, but to administer the publishing and collect royalties. How does or will the MLC interact with these companies or replace them? Can you describe your relationship with the independent distributors such as CD Baby, TuneCore, and DistroKid?
Yeah, great question. So those companies and many others like them started largely as independent distribution companies for sound recordings. Some of them have now added publishing administration services as well. So in that respect, they will become members of the MLC, and they will collect mechanicals on your behalf and then report them back to you. So if you have a client who's using one of the services, the first thing to do is to check and see whether the service even offers publishing admin, because not all of them do. And if they do, has your client chosen or selected that additional set of services? And if they have, then the same exercise that we described before applies. What does that cover, right? Because in that instance, if your client didn't put a sound recording up on that service, then they're not going to be getting publishing admin for a sound recording that company doesn't distribute. So again, there may be things that fall outside of that relationship, but some of those companies do that directly. Some of them use other providers. A great example of a company that both does that directly and then provides that service for other companies is Songtrust. And I only mention them because one of their executives is also on our advisory committee. And that question came up in a tweet months ago, and the response was, "We've got you covered." So again, there are a lot of people in the market today that provide services for songwriters. And as a lawyer, you can help them to discern whether or not those providers are providing administration services for them, such that they don't have to connect with us directly because those partners are for them.
Okay. And there was a question that's tangentially related to this. I can't remember who asked it, but if a songwriter is signed up with a publisher just as an admin deal rather than having a publishing deal, can they trust their pub administrator to be monitoring this information as well?
Again, it depends on the nature of the deal, but certainly some of the largest publishers administer catalogs for other smaller publishers. That's quite common. And I think the expectation among the publishers that I've spoken with who also provide those admin services is they're going to do that as a part of their admin deals, but you as a lawyer can confirm that. And I think when in doubt, make a phone call to your contact there, because it's much better to be sure than it is to get it wrong and then have that money sit there and not get collected.
Mhm.
Okay. This one, I'm going to combine two questions. The first part of this question is from Sarah Elabieri. How often will royalties be paid out to the clients / members? And the second part is from Richard Jefferson. What is the timeline for being able to see the unclaimed royalties?
Sarah, great to hear you as well. So we will be paying out royalties monthly for folks who were being paid under the previous compulsory license. That will be no different. The compulsory license before the MMA required monthly accounting, but many large digital services were accounting under voluntary arrangements, and those voluntary arrangements were often quarterly. So for those folks, the cadence will change and will be more frequent, but we will be monthly. And then the second question, remind me, John, and actually I just saw, we will try to pay everybody electronically, Sarah. No cryptocurrency options just yet, but I imagine that will be on the future horizon at some point. And heirs of a catalog can become members if they're entitled to collect mechanicals. That's the key. If you're entitled to collect mechanicals, you can join. There are some companies that own income shares that are no longer tethered to a writer in any way. They've just bought a share of the work. They can become members because they're entitled to collect the mechanicals. So the second question there, second part of it, John, was?
Yeah, the second part of the question, and maybe Kay, you'd be geared to answer this, is what is the timeline, if there is one, for being able to see the unclaimed royalties?
That I do not know. I don't have an answer to that. That would be, do you know, Kris?
Yeah, it will be sometime in the spring, along with the royalty distribution. There are two kind of buckets to that. The first bucket might be new unmatched or unclaimed royalties from that first January period, right? As we get the first few files in January, if any of that is unmatched, then we'll be making that available. And then, of course, in February, when we get whatever historical unmatched people submit, then we'll add that to the mix. It'll all be available in the same interface. And, but we've got to get that in order to then put it out. So it will not be before we get it in, and probably sometime toward April when we do that first distribution. And we'll have more information about specific dates as we get into 2021. We're about 2 steps ahead of all of you, and that's probably step 2.5 right now.
So, but there will be a publicly accessible claiming portal that people will be able to go in and see all of that. So
the data will be publicly available, so people will be able to see it, but claiming will be different because, again, the claiming will be based on membership, and to the extent that someone is not a member but they see something, that's sort of an interesting logical question. Could you, in theory, not be getting paid on an ongoing basis but have had historical activity? I think that's probably unlikely, but again, I think the answer we would have then is become a member. The way that streaming works, generally speaking, is that if a track is being streamed in any given month, it's probably being streamed every month to some degree, because again, it's a consumption model. People listen to the songs they like over and over again, not just once. So yes, there will be a public component that will allow people to see that unclaimed, and then there will be a component in the portal for members who can both then see it and claim it as the people entitled to be paid.
Okay. This question comes from Dina Hellerstein. Will the MLC make available its matching data to digital platforms that are not able to take advantage of the blanket license for streaming mechanicals? So
again, the data that we, the works data, will now be publicly available in January. One of the ways it'll be publicly available is there'll be a search area on our website where you can go and just type in searches, and that will look functionally like what today you can do to some degree at the PRO websites or Sound Exchange. But there will also be a way to download the entire musical works database in bulk. And we just started to talk about that. I think we have a webinar scheduled next week for it. But essentially, we're going to make snapshots of the database available on a weekly basis. There'll be $100 setup fee, and then it'll be like 20 or 25 bucks a month to get weekly snapshots for as long as you want. If you only wanted one snapshot, you just pay the setup fee, and then that's all you have to get. And that very low fee is, again, statutorily driven. The law says we can only charge a marginal cost intended to reflect the cost of providing the data in this way, not all the costs to assemble the data before we provide it. So that's where we're starting. We tried to set that price really low, and then we'll revisit that over time when we have a better sense of what the costs turn out to be, how many people want it. But again, in that way, those organizations that you mentioned, and that could be other administrative companies, it could be PROs, anyone who wants it can download all of it and get weekly updates of that data. And that will include the unclaimed and unmatched data as well, and use it for whatever purpose they want, other than fraud.
And speaking of fees, are the fees for the blanket licenses also statutorily driven?
Yes, those fees, the mechanical rates are set by the CRB, and that process is set to commence again in January. The MLC cannot be a part of that as an advocate, but we will be required to provide data, and so we will sort of sit on the sidelines and wait to see how those proceedings play out. And then once the rates are determined, then we will update our systems to reflect the current rates and then try to administer them. That's an important point. We cannot lobby or advocate on behalf of any particular party. Our job is to make sure that what is agreed or set by law gets implemented properly. And in that way, we are an administrative organization, not an advocacy organization like SONA and others that do great work on behalf of their stakeholders, their members.
Okay. There's a few questions about video. Now, you touched about video services briefly, but I'm going to combine a few questions here. What does the MLC do to interact with YouTube, if at all? And where does the MLC get involved with this with regard to Spotify's vertical videos or videos on TikTok?
Yeah, so it obviously gets a little confusing because lots of services are moving in both directions. YouTube started out as an audiovisual platform, and now they've got the latest iteration of an audio-only service that also has videos on it is YouTube Music. To the extent that they're operating a service and they're offering audio-only works, they can work with us and operate under the blanket, but where there is video content, they cannot. So in the case of Spotify, if they're making videos available, they've got to secure those rights separately from the rights that they can secure under the blanket. And that's something that a lot of the services are grappling with because, again, they try to present those offerings in an integrated way to consumers. And it may not be obvious that there are different things happening behind the scenes. Forgive me, I've got a leaf blower now kind of approaching my back door where my office is. So I'll put myself on mute and try to avoid that.
Okay. Is there any interaction between the MLC and the Harry Fox agency? And is it correct that Spotify has an exclusive deal with Harry Fox? This question comes from Helen Yu.
Thanks, John. You're gonna have to tell me because we've hit peak leaf blower here, and yeah, it's going to get worse, I think, for a moment. The answer is that HFA, we selected HFA to be a vendor of the MLC. And in that way, HFA is assisting us with some of the administrative tasks that we've been performing behind the scenes. But payments will actually be sent out by a different vendor. Again, we're building all of our processes, and there are lots of different vendors and partners that we're working with. HFA is one of them, but the actual payments are going to be sent out by a different vendor. And then, Helen, you asked about Spotify has an exclusive deal with HFA for payments currently. So what I will say, because I'm not intimately familiar with existing deals that we're not a part of, but up until January of 2021, services either had to do all of this work themselves or they had to hire a partner to do it for them. HFA and Music Reports are two of the names that you're probably familiar with. These are companies that provided those administrative services to digital companies. Going forward, the MLC will be stepping in and providing the services that they used to provide for everything, for any of the activity that's under the blanket. And we will also be providing matching services for all of the usage data that digital services provide. But digital services may still maintain direct or voluntary licenses with publishers or rights holders if they want. And if they do that, they can still hire another company like HFA or MRI to administer those voluntary licenses. So another question we get is, are you replacing MRI? Are you replacing HFA? The answer is no. They can still do things that we cannot do. And there are services outside of the audio sphere, the Section 115 sphere, like lyrics or audiovisual, where they provide services that we will never be able to provide, at least under the current iteration of the law. So your clients should not think that they're going to stop getting paid by HFA or MRI. What will likely happen is some of the revenue that previously was running through those companies will now come through the MLC, again, because it's being paid under the blanket license. So hopefully, Helen, that answers your question.
Okay. There's one more question from Michael Perlstein about the data required to register compositions. I know we've discussed this already, but if we can just briefly run through that one more time, and then after that, if each of you can just give your parting words of wisdom on what to look out for the MLC in the coming year.
So, Michael, thanks for the question. I hope you're well too. The short answer is, if you go to our website and you download that music data organization form, you'll see all the data points that you can submit in the registration process. It's a one sheet. It's like 10 or 12 questions, essentially, you can answer. So it's pretty straightforward. And then once your clients get set up in the portal, there is both a form they can fill out, or we call it a wizard, that essentially prompts them to answer questions. And it essentially walks them through the version of that form that is built into the portal. So the form is a great reference. You can't do anything with that. It's not meant to be completed and submitted, but you can see the data there. And then once you get in the portal, you can see the answers there. But it's stuff like the name of the writer, the name of the song. If you know some of the other co-writers and you want to throw that in, that's always helpful for us in connecting the shares. The share of the work that you're collecting as a member. If you have a publishing entity, the name of your publishing entity, and then some of those unique identifiers we mentioned. Also, if you do know the names of the sound recordings and the ISRCs, that's always good stuff. If you know the hit song featuring your composition or your client's composition, make sure we get that, because you'd hate to not get paid on the most successful song if for whatever reason we have not yet made that connection. But again, the form will be helpful, and the portal sort of lays that all out. And I will say, your client can give you access to the portal. If you're self-administered, they can make you a user in your account. So if you want to get into this and your client would like you to do that, you all can be in the portal on their behalf. And for those of you that are more digitally inclined, that may be an opportunity for you to help your client within the portal and to serve them in a different way.
Okay, great. And then any last words for our viewers today?
Okay.
Sure. Well, thank you for having us. I learned a lot today, as I always do whenever I come to an MLC webinar. Songwriters of North America is going to be hosting, we've partnered up with the MLC on lots of webinars so far, but we're going to be hosting a lot of events next year. So I'm going to put our operations gals email in the chat if you want us to. We have what's called advocacy boot camps, and we will also be hosting what we're calling portal parties to help songwriters learn how to register their works. If you want us to do one for you or your clients, just email sarah@wearesona.com and we will come to you. And yeah, that's it for me. Thank you.
All right.
And I would just add, I put our website, and for this group, I put my email too. If I didn't get you an email at the beginning of the year when I kind of moved over to the MLC, so many of you were familiar names and faces. drop me a line. I'll either connect with you directly or we'll get someone on the team who can help you out with questions. But please reach out and please connect. There are lots and lots of questions. And like I said, we're trying to answer as many as we can, but we may not get them all. And certainly smart people will think of things we haven't thought of. So connect with us. Let us know what you're wondering. Lean in with your clients, and we're here to help. And, we'd love to do more webinars like this. I'm so happy, John, that you organized this. Thank you again. But not to take away from your business, but if any of you are affiliated with other organizations and you think those organizations would benefit from a webinar, we do these all day, every day, multiple times. So we can do a version of this for your organization, whatever group you come up with, and we'd be happy to do that. So please reach out and let us know how we can help. And again, I look forward to seeing you all someday when I can leave this room in my house.
All right, well, Kay, Kris, it's been such a pleasure. Thank you for sharing all this information. I know that it's an important mission for you guys to get all the right information out to everyone, and we're glad that we can be a part of that. I know we're talking about trying to get a part 2, hopefully sometime next year. So if we do get that organized, we'll make sure to have that announcement. But I hope everyone got a lot of information out of this. I'm sure they did. Just a reminder, if you haven't gotten the new link to the materials, which now includes the PowerPoint, it is in the chat box, and there is a lot of information in there, especially information on how to contact the MLC moving forward. So again, thank you, Kris. Thank you, Kay. Glad that you can share an hour and a half of your time with us. And we look forward to seeing how the MLC moves forward in 2021.
It was a pleasure.
All right.
Thank you.